Welcome to Black History That Everyone Should Know. Today's segment is on Thurgood Marshall, Associate Justice of the United States Supreme Court. My name is J.Earl Twyman, and I will be your host for today. Thurgood Marshall was an American lawyer and civil rights activist who served as Associate Justice of the Supreme Court of the United States from October 1967 until October 1991. Marshall was the court's first African American justice. Prior to his judicial service, he successfully argued several cases before the Supreme Court, including Brown versus the Board of Education. Thurgood Marshall was born in Baltimore, Maryland on July 2, 1908. He was descended from enslaved people on both sides of his family. His original name was Thurgood, but he shortened it to Thurgood. His father, William Canfield Marshall, worked as a railroad porter, and his mother, Norma Erica Williams, worked as a teacher. Marshall's parents instilled in him an appreciation for the United States Constitution and the rule of law. Marshall first learned how to debate from his father, who took Marshall and his brothers to court to watch cases. They would later debate what they had seen. The family also debated current events after dinner. Marshall said that although his father never told him to become a lawyer, he turned me into one. He did it by teaching me to argue, by challenging my logic on every point, by making me prove every statement that I made. Marshall attended Frederick Douglass High School in Baltimore and was placed in the class with the best students. He graduated a year early in 1925 with a B average and placed in the top third of his class. He went to Lincoln University, a historic black university in Pennsylvania. It was commonly reported that he intended to study medicine and become a dentist. But according to his application to Lincoln University, Marshall said his goal was to become a lawyer. Among his classmates were poet Langston Hughes and musician Cab Calloway. Initially, he did not take his studies serious and was suspended twice for hazing and pranks against fellow students. He was not politically active at first, but became a star of the debating team. In his first year, Marshall opposed the integration of African American professors at the university. Langston Hughes described Marshall as rough and ready, loud and wrong. In his second year, Marshall participated in the sit-in protest against segregation at a local movie theater. That year, he was initiated as a member of Alpha Phi Alpha, the first fraternity founded by and for blacks. In 1929, Marshall married Vivian Buster Bury and began to take his studies seriously, graduating cum laude with a Bachelor of Arts degree in American Literature and Philosophy in 1930. Marshall wanted to study in his hometown law school, the University of Maryland School of Law, but it did not apply because of the school's segregation policy. Marshall attended Howard University School of Law, where he worked harder than he had at Lincoln. His mother had to pawn her wedding and engagement rings to pay for his tuition. His views on discrimination were strongly influenced by the dean, Charles Hampton Houston. In 1933, Marshall graduated magna cum laude and first in his law class. After graduating from law school, Marshall started a private law practice in Baltimore. He began his 25-year affiliation with the National Association for the Advancement of Colored People in 1934 by representing the organization in the law school discrimination suit Murray v. Pearson. In 1936, Marshall became part of the national staff of the NAACP. At the age of 32, Marshall won the U.S. Supreme Court case, Chambers v. Florida, in 1940. That same year, he founded and became the executive director of the NAACP Legal Defense and Education Fund. As head of the Legal Defense Fund, he argued many other civil rights cases before the Supreme Court, most of them successfully, including Smith v. Allwright, Shelley v. Kramer, Sweet v. Painter, and McLaurin v. Oklahoma State. His most famous case as a lawyer was Brown v. the Board of Education of Topeka, the case in which the Supreme Court ruled that separate but equal public education, as established by Plessy v. Ferguson, was not applicable to public education because it could never truly be equal. In total, Marshall won 29 of the 32 cases he argued before the Supreme Court. During the 1950s, Thurgood Marshall developed a friendly relationship with J. Edgar Hoover, the director of the FBI. In 1956, for example, he privately praised Hoover's campaign to discredit T.R.M. Howard, a maverick civil rights leader from Mississippi. During a national speaking tour, Howard criticized the FBI's failure to seriously investigate cases such as the 1955 killings of George W. Lee and Emmett Till. In a private letter to Hoover, Marshall attacked Howard as a rugged individualist who did not speak for the NAACP. 2 years earlier, Howard had arranged for Marshall to deliver a well-received speech at a rally of his Regional Council of Negro Leadership in Mound Bayou, Mississippi, only days before the Brown versus the Board of Education decision. According to historians David T. Beto and Linda Royster Beto, Marshall's disdain for Howard was well known. He disliked Howard's militant tone and maverick stance and was well aware that Hoover's attack served to take the heat off the NAACP and provided opportunities for closer collaboration between the NAACP and the FBI in civil rights. President John F. Kennedy appointed Marshall to the United States Court of Appeals for the Second Circuit in 1961 to a new seat created on May 19, 1961. A group of racist senators from the South, led by Mississippi's James Eastland, held up his confirmation, so he served the first several months under a recess appointment. Marshall remained on the court until 1965, when President Lyndon Baines Johnson appointed him to be the United States Solicitor General, the first African American to hold the office. At the time, this made him the highest-ranking black government official in American history, surpassing Robert C. Weaver, Johnson's first Secretary of Housing and Urban Development. As Solicitor General, he won 14 out of the 19 cases that he argued for the government and called it the best job that he's ever had. On June 13, 1967, President Johnson nominated Marshall to the Supreme Court following the retirement of Justice Tom C. Clark, saying that this was the right thing to do, the right time to do it, and the right man in the right place. Marshall was confirmed as an Associate Justice by a Senate vote of 69 to 11 on August 30, 1967, 32 to 1 in the Senate Republican Conference, and 37 to 10 in the Senate Democratic Caucus, with 20 members voting present or abstaining. He was the 96th person to hold the position and the first African American to do so. Marshall once bluntly described his legal philosophy as this: "You do what you think is right and let the law catch up," a statement which his conservative detractors argue was a sign of his embracement of judicial activism. Marshall served on the court for the next 24 years, compiling a liberal record that included strong support for constitutional protection of individual rights, especially the rights of criminal suspects. His most frequent ally on the court was Justice William Brennan, who consistently joined him in supporting abortion rights and opposing the death penalty. Brennan and Marshall concluded that the death penalty was in all circumstances unconstitutional and never accepted the legitimacy of Gregg v. Georgia, which 4 years earlier had ruled that the death penalty was unconstitutional in some circumstances. Thereafter, Brennan or Marshall dissented from every denial or certiorari in a capital case and from every decision upholding a sentence of death. In 1987, Marshall gave a controversial speech on the occasion of the bicentennial celebration of the Constitution of the United States. Marshall stated, "The government they devised was defective from the start, requiring several amendments, a civil war, and major social transformations to obtain the system of constitutional government, and its respect for the individual freedoms and human rights we hold as fundamental today." In conclusion, Marshall stated, "Some may more quietly commemorate the suffering, struggle, and sacrifice that has triumphed over much of what was wrong with the original document, and observe the anniversary with hopes not realized and promises not fulfilled. I plan to celebrate the bicentennial of the Constitution as a living document, including the Bill of Rights and other amendments protecting the individual freedoms and human rights." Although best remembered for jurisprudence in the field of civil rights and criminal procedure, Marshall made significant contributions to other areas of the law. In Teamsters versus Terry, he held that the Seventh Amendment entitled the plaintiff to a jury trial in a suit against the labor union for breach of duty of fair representation. In TSC Industries versus Northway, he articulated a formulation for the standard materiality in the United States securities laws that is still applied and used today. In Cottage Savings Association versus Commissioner of the Internal Revenue, he weighed in on the income tax consequence of the savings and loans crisis, permitting savings and loans associations to deduct the loss from an exchange of mortgage participation interests. In Personnel Administrator M.A. versus Feeney, Marshall wrote a dissent saying that a law that gave hiring preferences to veterans over non-veterans was unconstitutional because of its inequitable impact on women. Among his many law clerks were attorneys who went on to become judges themselves, such as Judge Douglas Ginsburg of the D.C. Court of Appeals, Judge Ralph Winter of the United States Court of Appeals for the Second Circuit, Supreme Court Justice Elena Kagan, as well as notable law professors such as Susan Lowe Blouch and Elizabeth Garrett. Marshall retired from the Supreme Court in 1991 due to declining health. In his retirement press conference on June 28, 1991, he expressed his view that race should not be a factor in choosing his successor, and he denied circulating claims that he was retiring because of frustration or anger over the conservative direction in which the court was heading. He was reportedly unhappy that it would fall to President George H.W. Bush to name his replacement. Bush nominated Clarence Thomas to replace Marshall. This has proven to be a terrible choice because Clarence Thomas has done nothing during his time on the bench to protect individual freedoms and human rights. Marshall died of heart failure at the National Naval Medical Center in Bethesda, Maryland, on January 24, 1993, at the age of 84, after he lay in repose in the Great Hall of the United States Supreme Court building. He was buried in Arlington National Cemetery. His second wife and their 2 sons survived him. Marshall left his personal papers and notes to the Library of Congress. The Librarian of Congress, James H. Billington, opened Marshall's papers for immediate use by scholars, journalists, and the public, insisting that this was Marshall's intent. The Marshall family and several of his closest associates disputed this claim. The decision to make the documents public was supported by the American Library Association. There are numerous memorials to Marshall. One, an 8-foot statue that stands in Lawyers Mall adjacent to the Maryland State House. The statue, dedicated on October 22, 1996, depicts Marshall as a young lawyer and is placed just a few feet away from where the old Maryland Supreme Court building stood, the court where Marshall argued discrimination cases leading up to the landmark Brown versus the Board of Education decision. The primary office building for the federal court system, located on Capitol Hill in Washington, D.C., is named in honor of Marshall and contains a statue of him in the atrium. In 1976, Texas Southern University renamed its law school after the sitting justice. In 1980, the University of Maryland Law School opened a new library, which is named the Thurgood Marshall Law Library. Thank you for listening to this segment of Black History That Everyone Should Know, as we focused on the life and successes of Supreme Court Justice Thurgood Marshall. If you enjoyed today's segment, please take the time to hit like and subscribe to our channel below so that we can bring you more interesting topics on Black history that everyone should know. This is J.Earl Twyman wishing you nothing but love.